have the most, we may borrow all of our laws directly from the EU, but I think this will be the peg on which everything hangs, which is that is adequate levels of compliance, of ensuring adequate levels of compliance. Now, in a paper that I wrote some time back, basically, and this was about privacy, not data protection. I compiled a catalog of competing rights, which would always displace privacy. So privacy is in India, and of which data protection can be seen as an offshoot or a cousin of some sort. Privacy in India is kind of a oops baby, kind of, if you look at the case law, the constitutional case law, which is called out, it begins as a dissenting judgment and then it gets formalized into law, by the time you come to NAS Foundation, etc. But what's happened all along the way is that privacy is always kind of ritually invoked in case after case, but only in order to be jettisoned by a competing interest. Now, what sort of competing interests in India jettison private privacy? And an incomplete catalog would be public emergency and public safety, freedom of the press, criminal investigation, competing private interests, so for instance in divorce proceedings, the best interests of a child in paternity suits, public interest, that's the right to information, competing fundamental rights, HIV status. This is just an incomplete catalog of the various things that will displace privacy every time you assert it. So if you try to say that, look, I've got privacy, a very easy argument to the state is to say that no, I've got public emergency and public safety. Or the freedom of press demands that you give up your privacy, or a competing private interest. So the thing is that privacy in India is itself a very, very fragile right. And within this particular ecosystem, guaranteeing, we're not able to guarantee, are we ever going to kind of arrive at a state where we can be regarded as adequate on the yardstick of enforceability, not on the yardstick of principles. On the yardstick of principles, it's still possible. I still think that if they did a better copy-paste job, we may end up with a better regime of data protection. But will our enforceability ever match up to the expectations? I'm hopeful. I hope that that's done. But today the impediments are, for instance, she mentioned that an adjudicating officer can adjudicate cases up to 5 crore. But what's neglected in this is that there are, the rules also say that beyond 1 lakh, if you're claiming more than 1 lakh in damages, there's a 2% levy on that. So basically, you're talking about paying a fee of 10 lakh if you want to punish a company, if you want to claim the maximum amount of damages of 5 crore. How many of us have 10 lakh to invest in an adjudicating officer? And really, anything less, would it really penalize a company? What's the, how do you go about adequately taking companies to task? So, these are kind of broader areas that we also need to look at. It's not only about bringing our textual law in conformity with what the EU would like, but I think that the promise that EU data protection holds out to us is that because of the wedge of EU data protection laws, if they're able to kind of bring in a systemic change in the way that we, we do criminal procedure or civil procedure, if they're able to bring in a quicker redressal system, somewhat data protection law on the lines of the RTI Act, which is speedy and efficacious and a people's remedy. That would make us, that's an important kind of way forward, on the path towards adequacy.
We now have
are both first-year National Law School students. Since joining law school, and it's not been very long since they entered, they've been very interested in law and technology issues. Aradhya has also done a moot on Section 66A, which was a hot topic for quite some time and continues to be, while Sarthak is working on data protection in the Consumer Forum. So I invite both of them to present their paper on this issue.
Good afternoon. So as we have seen till now, the debate that has been focusing on India-EU data protection debate. So the title of our paper is India-EU data protection debate, reconsidering the alternatives. The focus of our paper is the adequacy assessment requirement and the whole debate going on that whether India is adequate or not. Now, however, what we are going to focus is not that whether India is adequate or not, but the whole idea of this debate itself, the framework in which this debate is currently working. So we are going to deal with 3 main issues. First, what is the current framework of the debate, which will be just a summarization of points already made. Second, what is the problem in the current framework of the debate? And third, what is the alternative framework that we try to suggest through our paper? So moving on to the first point, that the debate of adequacy assessment, and a good food for thought which was given by Prashant about the entire chronology of how reasonable security practices rules were actually passed in India. Yeah, right. So if you see right after that, DSA comes with the same paper, same white paper, and arguing in 27 pages that look, this are data protection rules, and India satisfies this principles. Now, what are the problem now? So adequacy assessment, first of all, is very, as we all know, is very important for the BPO industry in India and for general corporate industry, corporate sector in India, because EU has a large amount of data, and as we know that if EU declares India to be a whitelist country or data adequate country, data secured country, then there's a shift of presumption that you don't have to take consent, and if any data going to India is prima facie is going to a secure destination, and you don't have to follow derogations until and unless proved otherwise that the particular data is not secure, the particular transfer is not secure. So now the problem with this adequacy assessment requirement is this. So there are three arguments, three problems that our paper tries to present. Is the first, that it's interfering with the domestic standard of privacy, which Prashant in a very short, which Prashant actually told in very gave us food for thought for that. Let's see, they're saying, so how this adequacy assessment works is they see your laws, the domestic laws, they see the data protection laws. For example, if we see the debate that was going on, first Graham Greenleaf comes with his report on India's data protection 2010, that whether India is data secured or not, taking into consideration India's laws and several other things about the cultural relativity arguments and all. After that, we see that there were rules formed in 2011, and right after that, we see that there was white paper on data adequacy assessment of India by EU and released by DSCI, where they discussed that whether India followed the principles of adequacy requirement of EU on several grounds, which was based on Graham Greenleaf's report itself, the argument from the other side. And we see that there are further reports coming on by, as Prashant said, the 2013 report which came by EU. So all these debates are focusing on only one issue, is that whether India's current laws are adequate or not. However, the first problem that I have is that they are seeing the domestic laws, the general laws applying to all the data within the country. So for example, when you see the reasonable security rules, they are applying to the domestic data, that is Indian data, and data coming from other jurisdiction also. But the problem with this is that they are assuming that what standard of data protection EU requires, the same standard of data protection will be required by Indian domestic data also, and the data coming from other jurisdiction also. So what EU in fact is doing is that they are giving a de facto universal privacy standard to the world. In fact, they are forcing de facto universal privacy standard in the world. As in the first presentation we saw, so the first line of the presentation was the EU data protection regime is the beacon and it's standard for the entire world. But however, that's not true. That's not always true. And as Mr. Prashant said, that look, in India you don't always require this. In India you should not be forced to have the same data protection requirement as EU has. Secondly, which ties up with my first argument, is that it skews the domestic priorities. So in India, of course, these arguments come from many corporate sector, and which I am not saying that I am not promoting particular priority, but say in India, one example, to give an example, an argument can be that India is a developing country. India now, the focus of India is to increase the access to internet, to provide to incentivize the companies to provide as much free service on the internet as they want, and in exchange of that, of course, they're going to share your data for some money so that they can share it with marketing agency and you can get further advertisement. So the current priority of India might not be the privacy or the greater privacy, but Indian priority might be something else, might be the free service or free access or something like that. However, I'm not saying that that's a particular priority that India should follow, that's a debate. But the concern of mine is that the priority should be determined on the domestic concerns rather than the concerns of data import that we are looking forward to. So the current concern for us is that, look, we want data from EU, and the data privacy standard that we are proposing in India would be based on whether we can import data from EU or not, rather than the domestic concern. Though this is not official concern, but as Prashant pointed out, that there's a huge politics behind all this reasonable security policies and everything which is coming out. So here, this is the problem with adequacy assessment requirement itself. So you are assessing the law of that country, general law of that country, which is meant to protect all the data in that country, not specifically EU data. And there is a problem that they are forcing a standard privacy which EU aspires to on all the data that is there in the country. And which screws, of course, domestic priority, as I said the example, and the domestic priorities has to be decided on the basis of domestic concerns. I'm not saying there's particular priority, but if privacy is our priority, or if certain standard of privacy is our priority, then that should be decided on the domestic concerns rather than the concern of data import. The third problem is to accommodate adequacy requirement of difficulty in accommodating the adequacy requirement of several jurisdictions. So here, currently we don't have that problem, but in future that's a very big problem that can arise. So if we see Rule 7 of reasonable security and reasonable security practices rules, Rule 7 says that India will export data only when there is same level of protection in any other jurisdiction. Now the problem is, suppose today only EU has that adequacy assessment requirement. In fact, many countries have, but the concern for India is only EU. Tomorrow there's some other jurisdiction which wants adequacy assessment adequate data protection requirement in order to have the data export. So the problem is, how do you accommodate these different adequacy requirements through a single domestic law? So if we can have only one rules for reasonable security practice that applies to all the data within the country, but say data is coming from China, data is coming from EU, data is coming from any other country, all want they have their own standard of what is adequate. How do you accommodate all these adequacy requirements through a single domestic data? This is a very practical problem which will arise very soon. So now that's the problem. Now we are presently arguing in the framework of debating that, look, that India is data adequate. The other side will say, no, India is not data adequate. And hence we submit that, look, there has to be a shift from this framework of debating whether India is data adequate, whether India is data secure according to its standard, from a different to a different level, that whether India can provide data, whether India can provide this much the protection that EU requires to EU data itself, which my co-author will come and talk to you about. That what is the alternative that you suggest, the alternative framework for this debate, because at the same time we have to recognize that EU has certain standard of data protection. You cannot say that, look, if it comes to India, we are not ready to protect. However, at the same time, we have to recognize that the standard of protection which EU data aspires for, the same standard of protection cannot be forced upon on Indian data or Indian domestic data. So with all this, I invite my co-author to present.
I will be dealing with the alternatives available to the parties concerned in case the importing country is not listed on the whitelist. We further suggest that the only way to break the India-EU logjam is not through changing India's data protection legislation, but evolving a new model based on the already existing alternatives. The first alternative is the standard contractual clauses. Now, SCCs are a set of model clauses approved by the EU which provide an adequate level of data protection. They can be concluded as between a data controller and another controller, or between a data controller and a data processor located in a third country. Now BCRs have two serious limitations. First, BCRs can only be used for intra-group transfers unlike standard contractual clauses and the safe harbor route, which I'll be mentioning subsequently. Secondly, adopting BCRs, as pointed out by Mrs. Jindal, is highly time-consuming and expensive. This is shown by the fact that by 2009, only two companies, that is General Electric and Philips, had got a BCR approval. Now the benefit of BCRs is that they are prepared by the companies themselves, unlike the ACCs. Thus there is a certain amount of flexibility available in case of BCRs. Now coming to the third alternative, which is the Safe Harbor Agreement. Now the Safe Harbor Agreement is an agreement signed between the EU and the US, ensuring transfer of personal data from an organization established in the EU to one established in the US without breaching the export ban as contained in Article 25 of the Directive. The agreement contains a list of privacy principles which were agreed between the two parties. Now, in order to get a safe harbor status, a company must see that it is subject to the jurisdiction of either the Federal Trade Commission or the Department of Transportation. If this is done, the company then needs to state publicly that it is complying with the safe harbor privacy principles. Thus, the Safe Harbor Agreement, or the SHA, envisages a self-certification regime. The enforcement under the Safe Harbor Agreement is done by a three-tier process which includes verification, dispute resolution and remedial measures. Firstly, under verification, the organization should conduct an audit in order to ensure that its privacy policy is in line with the safe harbor privacy principles. This audit can either be done by the company itself or by an independent agency. Now, under dispute resolution, a company can choose a private sector organization that offers dispute resolution of the safe harbor agreement. The benefits of the safe harbor agreement is that mere self-certification by a company give rise to a presumption of adequate protection of data for its transfer from the EU to the US. No prior approval of any data protection authority is required before a transfer takes place. Further, in case of a safe harbor transfer, the governing law is the US law, unlike the standard contractual clauses where it is the law of the data exporter. This, coupled with the fact that a US body resolves dispute, gives an added level of comfort to the US importers. Moreover, complex jurisdictional issues that might arise in case of SECs does not arise here. Now, coming to the criticism of the safe harbor agreement. Firstly, under the safe harbor agreement, the companies conduct an audit of the privacy policies themselves. Though they do have an option of conducting this audit through an independent agency, they hardly seem to exercise it. Secondly, the FTC or the DOT do not proactively oversee the policies being followed by self-certified companies under the SHA. They act only when there is a complaint from a dispute resolution body. Thus, the SHA envisages only a complaint-driven system as opposed to a system where the FTC or the DOT proactively oversees the policies being undertaken by a company. Thirdly, even it has been found that even in such a complaint-driven system, the enforcement agencies hardly initiate action against the companies. Now, all the above criticism notwithstanding, we propose that India and EU should sign an agreement similar as the Safe Harbor Agreement. This is due to the following reasons. Firstly, unlike the BCRs, transfer under such a model can also take place from an organization to organization, as opposed to an intra-organization transfer. Secondly, unlike the SECs or the standard contractual clauses, one does not need to enter into a contractual agreement for a data transfer under this rule. So if a company enters into a contractual agreement with each and every exporter it is contracting with, it might create problems when an organization plans to import data from several organizations in the EU. Once you have a safe harbor status, you can import data from any organization in the EU without separately contracting such organization. So this increases efficiency and effectiveness. Thirdly, unlike the standard contractual clauses, the importer is not subjected to the jurisdiction of the laws of the exporting country in this model which we propose. Thus, complex jurisdictional issues might not arise in such case. Further, once a certain set of privacy principles are agreed between India and EU, only organizations willing to import data from the EU need to implement these privacy principles, and not each and every organization. Thus, these privacy principles will not be forced down upon each and every organization, as will be done in a scenario where a general data protection legislation is enacted. Now, we acknowledge that certain deficiencies exist in this model, since it has been based on the safe harbor model. We suggest that these deficiencies can be remedied if it is mandated that the company should conduct an audit of its privacy policies through an independent agency only. In addition, a powerful regulator should be put in place, unlike the FTC or the DOT, which hardly initiates proceedings against the erring companies. However, we suggest that the mechanism of self-certification should not be done away with, as it ensures efficiency and prevents bureaucratic red tape, which might be there in a model where certification is required from government agencies. Thus, the final model we propose is this, which should be based more or less on lines of the safe harbor agreement. Thank you.
Panel. Please speak into the mic, state your name, where's the mic? And identify which member of the panel you would like to ask your question to. Also, is it online, the Skype connection? That's not happening? Okay, great. So,
you can note the questions to.
On my that the Cyber Appellate Tribunal is constituted in Delhi, and after the disposal of the case, we may move to High Court.
That's the appeal process.
We may move to the Appellate Court.
Yes.
That is the appeal after its disposal. So where will the jurisdiction be vested?
After the appellate tribunal.
No, after the Cyber Appellate Tribunal. And you told that the Cyber Appellate Tribunal is constituted in Delhi, after any case is disposed from the cyber appellate tribunal, we may move to High Court. So I am asking that what will be the jurisdiction of that? Which High Court? If any,
So, are you asking that if the appellate tribunal has made some order